We'll begin talking about limited partnerships. We spoke before about how businesses are always trying to combine the best aspects of limited liability and avoiding double taxation. And limited partnerships are designed typically to pick up both of those attributes. So, one advantage of a limited partnership is that it has limited liability for the limited partners. Notice that is carefully stated because there are also general partners in a limited partnership. The limited liability applies only to the limited partners. The second advantage is that it avoids double taxation. So the organization does not itself pay taxes. There's a direct flow through of both profit and loss to the owners. In other words, to the partners, the limited and general partners, there's a direct flow through of the profit and loss. You should note on the tax issue that limited partners can offset passive losses only against passive gains. So they couldn't, for example, deduct any losses from an investment in which they were not active against their active income. The limited partners are not active in a limited partnership. So they couldn't deduct those losses against, let's say, their salary. So when you're at this level of making investment choices, you really need to be consulting with accountants, tax attorneys, etc., to make sure you're getting the attributes that you want out of the business organization. How do you create a limited partnership? A limited partnership is what's called a creature of the state. In other words, you need state approval before you can exist. This is unlike a regular old-fashioned partnership where you can create one just by agreement. For all of the business organizations we will be discussing from here on out, they are creatures of the state. Therefore, how do you create them? There are basically two documents. One is a document that you file with the Secretary of State. And by Secretary of State, I mean the Secretary of State in the state where you are creating the organization. I'm not talking about the federal government, Secretary of State. Secondly, you're creating an internal agreement. This is an agreement about what the rules are going to be for the operation of the organization. So the first document will be publicly available with the Secretary of State. The second document would not normally be publicly available unless it's for a publicly traded company. It would simply be an internal agreement among the owners. One important caveat with limited partners is that the name itself must include that it's a limited partnership. It must have the words limited partnership in its name. The reason for this is to put creditors on notice that they cannot get to all of the partner's assets to try to get reimbursement for a partnership debt. You have to put the creditors on notice of that, otherwise it may not be effective. Your book notes LLLPs, which are called limited liability, limited partnerships. These are a variant of limited partnerships. They don't exist in California, so we're not going to give them too much time. Now, who owns a limited partnership? There must be at least one general partner. This general partner has the same sort of characteristics as a partner in a regular old partnership. In other words, they have unlimited liability for partnership debts, they owe fiduciary duties, they owe obligations to serve. So everything we learned about partners in regular partnerships, that applies here to the general partner. You must have at least one general partner, although you can have as many more as you want. In addition to that, a limited partnership has limited partners. You can have as many as you'd like. However, it's often limited because of the rules relating to the trading of securities. In a separate podcast, we're going to talk about securities and SEC enforcement of rules relating to the disclosure of information. But for our purposes right now, I just want to point out that some limited partnerships are publicly traded. You can buy them on the stock market. They may have thousands and thousands of limited partners. But many limited partnerships are not publicly traded, and they're meant for privately traded investors. And because certain reporting rules get triggered when they go larger than a certain size, They tend to be limited in the number of limited partnerships. The traditional rule was 35. If you went over 35 investors, then that triggered a lot more reporting requirements with the Securities and Exchange Commission. So often they were smaller than that. That number has risen over the years, and you should always check what the current rules are. Now, what do limited partners look like? They have no personal liability for the company debts. The worst case scenario for a limited partner is that they will lose their investment, but there's no personal liability beyond that. Limited partners do not owe fiduciary duties. They are not in a fiduciary position. They're not in a position of trust and confidence. They are simply passive investors in the same way that if you own a share of stock in Coca-Cola, you don't owe a fiduciary duty to serve Coca-Cola. You're simply a shareholder. It's the same thing with a limited partner. You're simply a passive owner. You simply own an interest in a business, but without fiduciary duties. At the same time, you have no right to manage the business. Again, limited partners are not like general partners. They're simply passive investors. What are the rights and liabilities? For general partners in limited partnerships, it's the same as for partners in partnerships. They have a duty to serve. They have an obligation to share losses. Everything we learned in partnership law, that applies to general partners in limited partnerships. For the limited partners, they have a right to share in profits according to the agreement. If the agreement is unclear, then they share in profits in proportion with their capital contribution, which is another way of saying in proportion with their original investment. There's no personal liability, as we mentioned before, for any losses beyond that investment. There's no right to participate in management. However, the limited partners do have a right to inspect the company records, and the reason for this is obvious. If the reason you have invested in some company is so that hopefully you make money from it, you have a right to inspect the company's records, at least enough of the financial records to see how much money is being generated and to see how much is being paid out. Any records, in other words, that are legitimately related to your investment. You do not have a right to vote on normal management issues because you are not a manager. You're simply a limited partner. However, if there is an extraordinary business decision, then there is a right to vote. What is an extraordinary decision? It would basically mean that the company is ending its business as it currently exists. For example, by selling out the business, terminating the business, merging with another company. In other words, a decision so big that it means an end to the company as it currently exists. No fiduciary duties are owed by limited partners, obviously, as we mentioned before, and there is a right to bring derivative suits. We're going to come up against this term again. What's a derivative lawsuit? We'll encounter derivative lawsuits again when we get to corporations. The problem is, how do you assert the business organization's rights when the management won't do anything? Derivative lawsuits allow some passive owners, for example, shareholders of corporations and limited partners and limited partnerships, to sue on the behalf of the company in certain circumstances. Why would this even happen? Well, let's just suppose that you are a limited partner in a limited partnership. Obviously, you're not managing the business, you're a passive owner. However, the general partner is managing it, and let's just say that she enters some contract to provide services for the business, and she's using this in a way to just siphon off money from the business to get it all for themselves in a way that is basically theft. Who would normally bring a lawsuit on behalf of a limited partnership against the general partner who is stealing from the company? Well, it would be the general partner, but she's the one who's supposed to be managing the business. She's the one who has fiduciary duties. Is she going to do it, for example, in this situation where she's busy stealing money? Well, she's not going to sue herself. So that's the problem that is presented when there are passive owners who cannot be involved in the management of the business, but they see the managers of the business are not protecting the true interests of the business. That's when shareholder derivative lawsuits may become appropriate. However, you can't simply file these lawsuits on your own. Why? Well, for a couple of reasons. One is that it could instead be a nuisance lawsuit against the company to try to hold them up to pay off some settlement that is not really owed. Suppose that you're just a jerk. You could buy an interest in a whole lot of businesses, corporations, or limited partnerships, file some stupid lawsuit against them to try to get them to pay you off to avoid the legal fees. You could make a lot of money by sort of being a leech on businesses, and courts are not going to allow you to do that. The second reason why is because you may be trying to take advantage of the situation. For example, finding a company where there's a business problem and then investing in that company just so you could bring a lawsuit later on. And that's not what derivative lawsuits were intended for. So the requirements before you bring a derivative lawsuit are that you had to have held ownership in your own name at the time of the alleged wrongdoing. And you must have made a demand on the company to pursue the claim itself, and the company declined to do that. Then you have to petition the court for permission to file the lawsuit. The judge will look this over to see whether, on the face of it, it appears to be a legitimate lawsuit and you've met the other requirements. In other words, you were an owner at the time of the alleged wrongdoing, you made a demand, the demand was declined by the company, and if all of that is shown, then the court will permit you to go ahead and pursue your claim. This doesn't mean that you win. It simply means that you can go ahead and pursue the lawsuit. Here's an example. Suppose that Lopez Company, as a limited partnership, was owned by Abel, Beatrice, and Chris Lopez. Abel was the general partner, and Abel, Beatrice, and Chris each owned equal shares of the company as limited partners as well. Incidentally, Abel can be both a general and a limited partner. It's very common for general partners to be paid for their services with one or more shares as a limited partner. Abel and Beatrice start looting the company, in other words, stealing from the company. Chris demands that they stop, but they refuse. Chris can file a derivative lawsuit with court approval, as we discussed, and the name of that derivative lawsuit would be Chris Lopez, a limited partner on behalf of Lopez Company, a limited partnership, as a derivative action versus Abel and Beatrice Lopez. Now, note that if Chris is successful in this lawsuit, who's going to get the money? Hint, not Chris. Chris is pursuing the lawsuit on behalf of the company. The company will get the money. Chris will certainly benefit because of his partial ownership in the company, but this is just Chris acting on behalf of the company. Do you have any right to assign your interest in a limited partnership? In other words, suppose you want to give these rights to your daughter. Can you do that? Generally, these rights are contained in the agreement. With general partners, they have the power, but they may not have the right to withdraw at any time. And that's the same as the rule with regular old partnerships. You have the power as a general partner or as a partner in a regular partnership to leave at any time, but you may be in violation of your agreement. So if you had an agreement that you would be a partner for, say, 5 years, and it's only been 2 years, you're violating the agreement. You can alter that agreement if permitted or if there's unanimous consent. General partners can also be added if there's unanimous consent. But what about limited partners? Can they withdraw? The general answer is to look at the agreement. Now, unlike regular old partnerships where there may or may not be an agreement that has been written, with limited partnerships, there's virtually always a written agreement because they can't even create the limited partnership without filing that certificate. So it would be very unusual if they could be a limited partnership with no written agreement. So look to the agreement. But in the absence of some provision in the agreement, it's governed by state statute. And a typical provision would be that you can withdraw your investment in a limited partnership on, say, 6 months' notice. Can you assign your rights to the limited partnership? The general answer is yes, because again, you're simply assigning a passive ownership interest. If you're a limited partner in a limited partnership and you instead want the benefit to go to somebody else, your daughter in our first example, there's no reason that from the company's perspective why that would be a problem, because you are simply owning a portion of the business. You are not actively involved in any of the management. These rights could be limited in the agreement, but they cannot be alleviated. There has to be some right to transfer the interest. Your ability to transfer the interest, however, does not mean that you no longer have any obligations. If, for example, you owe the business money, that doesn't go away simply because you assign your interest to your daughter.